Hafade, good afternoon. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Tuesday, October 18th, 2022. The time is 11:36 a.m. In compliance with the Open Government Law, notices for this public hearing were published in the Guam Daily Post and the Government of Guam Public Notice Portal on Tuesday, October 11th and Friday, October 14th, 2022. This hearing is being live streamed on the Guam Legislature's YouTube channel. Notice was also sent via email to all senators and all main media broadcasting outlets on October 11th and Sunday, October 16th, 2022. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. We have only one agenda item this morning. That's Bill number 299-36LS. And I will have the sponsor introduce that bill, including reading of the title and the sponsors. But I'd like to acknowledge the presence of my colleagues here this morning, including the sponsor of the bill, which is Senator Mary Camacho Torres, and our majority leader, Senator Telena Cruz Nelson. Thank you, colleagues, for being here. So I will allow Senator Torres now to introduce the bill.
Thank you, Madam Chair. Bill number 299-36LS was introduced by myself, Mary Camacho Torres, and co-sponsored by Telena Cruz Nelson, Therese M. Terlaje, Tina Rose Muña Barnes, Sabina Flores Perez, Amanda L. Shelton, Jose Pedo Terlaje, James C. Moylan, Christopher M. Dueñas, V. Anthony Ada, Joe S. Agustin, and Frank Blas, Jr. Bill number 299-36 is an to add a new section 13301.1 and section 13301.2 to Chapter 13, Title 19 of the Guam Code Annotated, relative to requiring reasonable efforts to preserve and reunify families and to establishing circumstances negating requirement for such reasonable efforts, and to amend section 13320A through F of Chapter 13, Title 19 of the Guam Code Annotated, relative to updating disposition hearing requirements, and to amend section 13324 of Chapter 13, Title 19 of Guam Code Annotated, relative to updating the timelines for the permanent placement of children, and to further add a new section 4303B6, section 4303B7, and section 4303D to Article 3, Chapter 4 of Title 19 Guam Code Annotated, relative to terminating the parental rights of a parent who subjects a child to aggravated circumstances. Simply put, Bill 299 creates new standards in Guam's Child Protective Act that prioritizes the health and safety of the child. Madam Chair, in the last year alone, over 1,600 cases were referred to Child Protective Services on Guam. That's more than 4 children every day that were either neglected, sexually assaulted, or physically abused here in our homes. The number of children in our foster care system has also grown to 604, which is 130 more children than this time last year. According to Child Protective Services, this increase can be attributed to greater awareness in the community, with more individuals contacting CPS to refer children in need. But that doesn't make the consequences any less devastating. Based on the data from the U.S. Department of Health and Human Services, most perpetrators of child abuse or maltreatment are parents of the child, accounting for 77% of all child abusers in the United States. This abuse, especially when experienced in early childhood, can have severe behavioral and psychological consequences, including depression, anxiety, higher prevalence of suicide attempts, post-traumatic stress disorder, eating disorders, substance use, and juvenile delinquency. The longer a child stays in foster care, the worse it gets. That's because children who are in long-term care often end up with multiple placements, experiencing more trauma each time they are moved. According to the American Academy of Pediatrics, these children experience a 63% greater risk of developing behavioral challenges than children in stable placements. Is it a wonder? As the National Child as the National Council of Juvenile and Family Court Judges declared, children have a very different sense of time than adults. Short periods of time for adults seems interminable for children, and extended periods of uncertainty exacerbate childhood anxiety. Madam Chair, I don't raise these points to berate the hardworking men and women of CPS. They work tirelessly with the resources they have to safely place our island's most vulnerable. Rather, I wish to underscore the grave consequences of our children lingering in the foster care system. And when I met with our social worker supervisors last year, many of them echoed the same concerns. And that is why I and 11 senators introduced Bill 299. Right now, Guam law lacks clear standards regarding family reunification. And what I mean by that is currently Guam's Child Protective Act does not specify when efforts to reunify the family are no longer required, nor does the law clearly state when a petition for the termination of parental rights must be filed by Child Protective Services. Bill 299 would address this in two fundamental ways. First, it would include aggravated circumstances as grounds for terminating parental rights. If a parent engaged in physical or sexual abuse of the child, a felony assault that resulted in serious bodily injury, attempted murder, or manslaughter, CPS must file a petition to terminate parental rights. Second, the bill would update Guam's timeline for permanency planning to comply with federal standards. Under the Adoption and Safe Families Act, which is U.S. Public Law 10589, state welfare agencies must file a petition to terminate parental rights when a child has been in foster care for 15 of the most recent 22 months in order to receive federal reimbursements for foster care, adoption, and kinship guardianship assistance. This we know as Title IV-E funding. Guam law does not have this requirement. Therefore, we are losing out on a potential federal fund towards local foster care. As a result, Bill 299 requires CPS to petition the court for termination of parental rights if the child has been under its care for over a year. The bill, however, provides an exception for parents engaged in services to include treatment for substance use disorder or mental health concerns or parenting skills, or if CPS has documented another compelling reason not to terminate. The bill also amends Guam's current permanency planning hearing timeline from within 2 years to within 12 months after the child's removal from the child's home. If there are aggravated circumstances, the permanency planning would take place within 30 days. And again, these changes are all consistent with the federal requirements established under the Adoption and Safe Families Act. Madam Chair, the bill before us today represents months of collaboration with Child Protective Services. Prior to drafting, my office sent invitations to Deputy Director Uggan, Acting CPS Director Lonnie Brennan, Social Services Supervisor Mayfei Muiko, and Acting Program Administrator Corinne Buendicho to meet with us and discuss this draft. Correspondence was sent by my office to these individuals on November the 15th, November the 23rd, and December the 10th of 2021. And in order to accommodate BOSS's schedule, the meeting was held on December 17th, 2021. And at this meeting, Ms. Mayfei Muko noted that Deputy Uggan was unable to attend, but that she and the team of supervisors were sent to represent on management's behalf. The team had been given an advance copy of the bill and approved it. But to ensure further due diligence following the meeting, my office sent an additional request to BOSSA for feedback. This time, the draft was sent to CPS's Case Management Unit, which included individuals who would be dealing with these matters directly. The group of individuals were sent the draft by Ms. Mayfei Muiko and Ms. Maylene Lizama. The case managers sent their collective feedback on April 13th, 2022. And so after incorporating everyone's responses, on April 18th, a final draft was transmitted to Acting CPS Director Ms. Lonnie Brennan. On April 20th, Ms. Brennan approved and supported the bill, stating that once enacted into law, this will help ensure that infants and children no longer languish in the foster care system unnecessarily, and that they have the opportunity to find permanent, loving homes as soon as possible despite their past traumas. The bill was then routed and received 11 co-sponsors before its introduction on April the 26th. I take the time to note these dates, Madam Chair, because I want to highlight the months of effort that CPS and my office put into this measure to ensure that each and every one of their concerns were addressed. I also want to take a moment, Madam Chair, to comment on the fiscal note which was shortly issued after the bill's introduction. In this note, DPHSS affirms the need to hire additional social work personnel. To be clear, the need for additional social workers existed long before this legislation, and frankly will remain without it. It is my understanding that even after this fiscal note came out, DPHSS didn't request for additional social workers in their fiscal year 23 budget requests. The requested amount for CPS was $981,918, of which the legislature appropriated all of the $981,935. With that said, I'm encouraged that with the full support of CPS and the Bureau of Women's Affairs and the 11 co-sponsors, the administration will do what is necessary to ensure the adequate resources are deployed to CPS to this end. In addition, should this bill become law and Guam elects to join Title IV-E, the federal government will pay 50% of the costs of administering the Title IV-E program, such as salaries of caseworkers and administrators, office space, etc., and 75% of the training costs associated with the program. And I raise this point simply to note that staff costs may be offset by future federal funding through Title IV-E, but that is ultimately dependent on public health applying for this program. But at the very least, Bill 299 makes the statutory changes that help us get closer to compliance should Guam elect to enter the program. And notwithstanding any fiscal discussion we have today, there really is no excuse, we all agree, for our children to stay in an abusive home. These may be new requirements for Guam, Madam Chair, but they are not groundbreaking. All 50 states, the District of Columbia, Puerto Rico, and the Virgin Islands have the same provisions, making Guam one of the only jurisdictions without it. And while I believe family life should be nurtured and preserved, nothing is more important than protecting our children. The right of a child to a safe, stable, and a permanent home must always be our primary concern. If we say we care about life, then this government must make timely decisions regarding kids in foster care. We cannot allow them to lose their lives to the child welfare system. And it is my hope that by passing this bill, more kids are able to experience the loving security of a family who is willing and capable of caring for them. And before I conclude my statement, Madam Chair, I'd like to read a portion of a letter that was sent to me by a foster parent who has granted me permission to read it on the record. And it reads, Senator Mary Camacho Torres, thank you for your efforts to increase the ability of the foster care system to prioritize the safety and security of our island's children. My husband and I became foster parents in Guam in 2018. Since then, we have fostered 9 children. Some came for only a short time as emergency placements. Some moved on to live with their family members. Others stayed with us and became part of our family. After 4.5 years in foster care, we recently adopted one of our foster daughters. Over the years, I have seen firsthand how the extended time of cases has added unnecessary burdens to our island's foster care system. She continues, the current length of foster care also places a financial burden on our island. Our foster children have lost their private insurance coverage 3 times in the last 4.5 years due to the number of foster cases exceeding the budgeted amount of funds for insurance. Additionally, the longer a child remains in foster care, the more money is required for monthly stipends and reimbursement. 2 years ago, we received notice that due to a shortage of funds, DPHS might discontinue stipends supporting foster children. Thankfully, the problem was resolved, but it showed the need for a renewed plan to provide for the island's most vulnerable. The excessive duration of foster cases also disqualifies the government of Guam from receiving federal reimbursement under the Adoption and Safe Families Act. However, the greatest burden of all is the burden on the children in the foster care system. Years of uncertainty only adds to the trauma they have already suffered. Children should not have to live in fear of returning to an abusive situation. Clearly defined legal grounds for terminating parental rights gives CPS the ability to put the safety of the child over the legal rights of a violent offender. Every child in the foster care system deserves a safe, loving, forever family, whether that family is found through recovery and reunification or through adoption. And that ends her letter to me. Thank you, Madam Chair.
Thank you, Senator. So for the record, in addition to the public invitations to provide feedback were sent to the following: the Department of Public Health and Social Services Division of Children's Wellness, the Bureau of Social Services Administration and Child Protective Services, to the Office of the Attorney General, to the National Association of Social Workers, Guam Chapter, to Harvest House, to the Guam Bar Association. We received a fiscal note from the Bureau of Budget and Management Research, BBMR, and in relevant part, it states that DPHSS will need to hire more staff for the Division of Children's Wellness to meet the aggressive timeline changes that are imposed. All the above requirements will require the DPHSS to hire additional personnel for the tasks of determining whether the listed conditions are satisfied. As per correspondence from DPHSS, the department will need additional staff to handle the added responsibilities of the proposed legislation. The total fiscal impact of the proposed legislation is estimated to be $530,728, $323,437 in salaries, and $207,291 in benefits. The Bureau notes that the bill does not appropriate any funds for the additional requirements that DPHSS will have to meet. DPHSS has stated that there are 8 preliminary positions essential to the implementation of 299-36 LS, and they provided a table. So 3 social worker 2s, 4 social worker 3s, 1 community program aide, for a total in salaries and benefits of $530,729. So now I'm going to invite the panel, and I guess we'll just go in the order that they signed in. So we'll begin with Helen Middlebrook.
Good morning, the senators. I am Helen Middlebrook, and I do thank you for this time to testify on Bill 299-36. I have come today not so much to comment on the bill, but to tell you a story that I hope you will remember as you consider the multiple changes Bill 299 addresses. This is a story that gets to the heart of why we must change and enforce laws that affect the lives of children whose parents fail them. I am the foster mother of the forgotten boys, Nero and BJ. This is their story. In late February 2008, CPS removed 4 siblings, 2 girls and 2 boys, all under the age of 7, from the custody of their mother and placed them at Ailey Shelter, a temporary shelter for children in need. 7 months later, a 5th sibling, another boy, was born. He went directly to the shelter at 3 days old, and there he stayed. In fact, there they all stayed. I learned about these children in early 2009. An article in the Pacific Daily News said CPS was looking for a home for a sibling group of 5 children, all with special needs. When I read the story, I knew 3 things. 1, CPS was asking for a miracle. It's difficult enough to place one foster child with special needs. 5 would be impossible. 2, I knew they were mine. And 3, I knew I could not take them. My house was full of biological children. Although they were starting to flee the nest, I still had 7 at home. Foster care homes were limited to a total of 6 children. My first hunch was correct. CPS never found one home for all those children, except the shelter. And that's where the children stayed for years. By the time the article had appeared, the first 4 had been in the shelter nearly a year. The baby had been there about 5 months. Too many years came and went then, and they stayed together in the shelter. While in the shelter, baby BJ and his next older sister showed that they had a rare genetic condition. As toddlers, their heads grew and they developed seizures. They were given a broad-range seizure medication, which is no longer used in the States routinely, and which I know for a fact was poorly monitored. It turned them into zombies and stole their precious formative years. After 5 years of lingering in the shelter, watching kid after kid come and go to foster homes, all the while wondering why they were not wanted, 2013 turned out to be a banner year for this group of siblings. The oldest a girl and the third oldest a boy were adopted and taken to Arizona by their new family. The younger girl was placed with a wonderful foster family at Anderson Air Force Base and was eventually adopted in December. And in August of that year, Nero and BJ started weekend visits with our family. BJ came to stay with us permanently in October, and Nero followed in February of 2014. BJ turned 5 the month before he came to stay. Nero was 10 when he came to stay in February. It had been a full 6 years in the shelter for him by then. And that, in my book, is criminal and abusive. And if I in some way could hold CPS, GovGuam, DPHSS, and Catholic Social Services accountable for that, I would. Life in the shelter is just a different form of neglect. It should have never happened to my boys. I have been told by other foster parents that after 18 months in foster care, there had to be a permanency plan. 18 months. All of those children should have been adopted long before they were. I should have never had the opportunity to be their mom. They should have had a mom and a dad years before that. But CPS couldn't even place them in foster homes. You can bet that I asked why they lingered so long in the shelter. The only answer I was given was, we wanted them to keep them together. What was the point of that? 5 children, 7 and under, were kept together when they could have benefited from being placed in foster homes, even if separated. BJ and his next older sister would not have lost all their development had they been in families who would have monitored the seizure medication carefully. In the end, they were separated. 2 are in Arizona, 1 is in Ohio, and BJ and Nero are here. But we will soon be leaving for Florida. All of us. Although BJ and Nero have been my boys since 2013 and 2014, they are still foster status. As of today, BJ has been in the system since birth, and he's been in foster care 5,154 days. Nero has been in the system 5,347 days. 5,154 and 5,347. Let that sink in, please. It's over 14 years. Now, you may ask why their last name is not yet Middlebrook, and that's a fair question. The answer has to do with the way GovGuam washes its hands of children once they are adopted. Some states give parents who adopt children out of foster care continued financial support. We do not. Once I adopt them, they are mine, lock, stock, and barrel, or more specifically, crooked bodies, developmental disabilities, seizure disorder, and all. And that would be fine with me, except that Nero has to have major surgery at Shriners. If he's still a ward of Guam, Guam will financially support his 3-month stay in Honolulu. If he is ours, there is no support. I hate that it comes down to money, but it's 3 months in Honolulu, people, and we're retiring. I long ago determined that I would not adopt BJ alone because of the forgotten children, particularly the forgotten boys. Nero was the most forgotten. Way back in 2008, CPS got involved when 3 of the 4 of the children went to the hospital with all the symptoms of malnourishment. Whoever had taken them to GMH had left Nero behind. I met the woman who carried him out of the squalid house he was in. She said he was nearly dead, and they had left him behind. I will not. Of course, if CPS had been constrained by law to actually push for permanency, they would have been nagging me for the last 9 years to adopt. But they haven't. In fact, it is quite clear from the behavior and the words of CPS, they have no great desire to see children adopted out of the system. Early in my journey with BJ and Nero, my primary goal was to get them out of the shelter with an eye toward helping them find adoptive parents. I spoke to the social worker about it numerous times, and once I was told, well, BJ might have a chance because he's still little and cute, but Nero is too old. No one wants him. No one wants him. If this is the heart of CPS workers toward adoption, a heart transplant is needed immediately. For some reason I have yet to understand, CPS would rather keep a kid in the system and give the parents chance after chance after chance to get the child back, even when it is clear the parents are not willing or capable of providing a stable home. At what point does a child's safety and a child's true welfare trump parental rights? The reunification or die mantra of CPS leads to insecure children and creates a backlog of cases in the courts and in CPS. Now, admittedly, if CPS had been nagging me to adopt, I would have told them what I just told you. The forgotten boys are now the dynamic duo, and they will become Middlebrooks as soon as the way is cleared for them to be adopted together. And in the meantime, you have a job to do. Fix this broken permanency system so that foster parents who want to adopt can move forward. Don't let one day turn into 5,347 days ever again.
Thank you, Mrs. Middlebrook. Ann Croker.
Hafaday, thank you for allowing Ohala Adoptions speak on the amendment of Bill number 299-36 LS. Ohala Adoptions is in support of the preservation and reunification of families. We are ultimately in support of an intact family unit. We are also in support of Bill number 299-36 when it speaks to not requiring state welfare agencies to reunify families when the agency has determined the existence of specific circumstances. We support and encourage the state's welfare agencies and/or courts to immediately dissolve parental rights in circumstances of aberrant behavior from the parent or responsible party in charge of the child or children. Circumstances such as abandonment, torture, chronic abuse, sexual abuse, murder, conspiracy of murder, solicitation of murder, felony assault, or termination of rights to a sibling of the child should automatically lead to involuntary termination of parental rights. Ohala Adoptions would also like to continue to support Bill 299-36's previous amendment of the timeframes of termination proceedings as being in foster care or state care for 15 of the last 22 months. And once the full term of 22 months has come to pass and full term defined to help families reunify, that the case be brought to court within 30 days to start termination of parental rights, and reasonable efforts should be made to place the child with a permanency plan that includes in-state and out-of-state placements not to exceed 12 months. We would like to add that permanency plans should not include indefinite foster care that could lead to the child aging out of the system. Ohala would like to encourage the amendment of Bill number 299-36 to include federal guidelines from the Children's Bureau and Office of the Administration for Children and Families on involuntary termination of parental rights to include severe or chronic abuse or neglect, sexual abuse, abuse or neglect of other children in the household, abandonment of the child, long-term mental illness or deficiency of the parents, long-term alcohol or drug-induced incapacity of the parents, failure to support or maintain contact with the child, and involuntary termination of the rights of the parent to another child. In addition, we are in support of the termination of parental rights if a parent has committed sexual abuse or other sexual offense, child exploitation to include prostitution and/or pornography, a conviction of human trafficking or sex trafficking of a minor, in cases of committed rape or sexual assault of one parent to another, if a parent is required to register as a sex offender, violence against any one person in the household, long-term incarceration that requires the child to go into foster care with lack of alternative means of supporting the child or children, and when a newborn infant has been relinquished to safe haven or certified abandoned. OHALA would like to see an amendment of Bill 299-36 to include the verbiage of the Adoption and Safe Families Act, in which parental rights are terminated if the child was abandoned at birth, if the parent committed murder or voluntary manslaughter of another child of the parent, aided, abetted, attempted, conspired, or solicited to commit such a murder or voluntary manslaughter, or committed felony assault that resulted in serious bodily injury to the child or another child of the parent. Essentially, OHALA Adoptions would like Bill number 299-36 amended in such a way that Guam should be able to receive Title IV Part E funds of the Social Security Act. In conclusion, OHALA Adoptions would like to suggest this state take into consideration Part E, number 23 of Title IV, that the state shall not deny or delay the placement of a child for adoption when an approved family is available outside their jurisdiction with responsibility for handling the case of the child. We would ultimately like to see children not spend an unidentified amount of time in foster care when reunification cannot be obtained with the parent or family. We would also like to acknowledge that it is hard to place children in temporary homes when the people providing care are not eventually guaranteed to adopt. According to the National Conference of State Legislators, up to 80% of the children in foster care have post-traumatic stress disorder, major depressive episode, modified social phobia, panic disorder, generalized anxiety disorder, alcohol dependence, drug dependence, and bulimia as the most significant mental health issues. We encourage you to amend the bill number 299-36 LS to benefit the children being placed with the most supportive families and cut their time waiting in limbo for positive family placements, and help in any way possible to make sure all state entities enforce the timelines to make them happen. Thank you.
Thank you very much. Ms. Jane Flores.
Thank you, Senators. My name is Jane Flores. I'm the Director of the Bureau of Women's Affairs and the Administrator of the Governor's Community Outreach Federal Programs Office, which handles our Office of Violence Against Women grants. The Bureau of Women's Affairs respectfully submits this testimony in favor of Bill 299. Over the past several years, the BWA has been in discussion with the Child Protective Services Division of Guam Department of Public Health and Social Services, with the Department of Youth Affairs, with OHALA Adoptions, and with the Office of Senator Mary Torres about the issue of strengthening Guam's termination of parental rights laws. BWA's concern was brought to the forefront when Senator Torres's bill to terminate the parental rights of a person convicted of a sexual assault that resulted in the conception of a child was signed as Public Law 35-91 in 2020. This law is known as the Rape Survivor Child Custody Act, and it was enacted because one of our grants, we could not get the full funding unless we had this law in place. BWA was and still is concerned that parental rights should be terminated if the child is the victim of sexual assault perpetrated by the parent. If a parent rapes a child, that parent should no longer have parental rights over that child, period. Currently, 19 GCA Chapter 4, subsection 4303 states in part The parent-child relationship may be terminated with respect to the parent by whom or on whose behalf such petition has been filed, where the court finds that such termination is in the best interest of the parent and the child. BWA is relieved that Bill 299 clarifies that the child's health and safety should be paramount concern, not that of the parent. In addition to Public Law 3519's application to the statute of the termination of parental rights of a perpetrator of sexual assault that resulted in the conception of a child, 9 GCA Chapter 9, subsection 4303 lists only the following as reasons for termination of the parent-child relationship. 1, that the parent has abandoned the child in that the parent has made no effort to maintain a parental relationship with such child. 2, that the parent has substantially and continuously or repeatedly neglected the child. 3, that the presumptive parent is not a natural parent of the child. And 4, that the parent is unable to discharge parental responsibilities because of mental illness or mental deficiency, and there are reasonable grounds to believe that such condition will continue for a prolonged, indeterminate period. The Guam Code says nothing about terminating parental rights because of severe abuse of a child, such as in the case of the 2 teenage boys found last year brutally beaten, starved, and tied up for days at a time. Instances such as these are not covered in the current statute, so there is clearly and tragically a need to update this law. Bill 299 also updates the time period during which the child's family has or will become willing and able to provide the child with a safe family home from 2 years to 15, as has been previously testified, to 15 of the most recent 22 months that the child was first placed under foster custody by the court. This time frame, as noted in the bill's legislative findings and intent, mirrors the Federal Adoption and Safe Families Act. Importantly, the proposed legislation does consider circumstances when a parent or parents wanting to get their child back cannot do so because they lack access to services available to help that parent or parents overcome the obstacles under which their child was taken from them in the first place. BWA suggests that lawmakers inquire with CPS as to which of these services may be lacking or need funding, and then substantially increase the funding for those services in question. BWA has several projects in the works right now to help mothers who do not have a high school diploma to be able to earn that diploma or equivalent so they can empower themselves and provide a better future for their children. BWA supports and will assist whenever and wherever possible to help with family reunification efforts when that reunification is in the best interest of the child. Because while reunification of the family is a laudable goal, it is nevertheless a goal that is sometimes just not possible. When that is the case, or when a parent has so abused a child that the child's life or future is in jeopardy, our system, Child Protective Services, our court system, and our law enforcement system must put the interests of the child front and center. As unfortunate as it may be, sometimes the only way for a child to have a chance at life is to get away from an abusive biological parent. Sijus Masi for the opportunity to testify in favor of this very important piece of legislation.
Sijus Masi. We'll now hear from Mayfe Muko and the Department of Public Health and Social Services.
Good morning. I'm here to support Bill 229, and my supervisor, Ms. Crystal Gooden, will read a testimony.
Ms. Gooden.
Buenas and half a day, Honorable Therese, Terlaje, Speaker of the 36th Guam Legislature and the Committee Chairperson on Health, Land, Justice, and Culture, as well as Senator Torres and Senator Nelson. My name is Crystal Gooden. I'm the Social Supervisor 2 for the Bureau of Social Services Administration. The The Department of Public Health and Social Services is in general support of Bill 299-36 and would like to comment on the bill. We support the legislature's intent to establish statutes within the Chapter 13, Title 19 of the Guam Code annotated for reasonable efforts to preserve and reunify families, define grounds for termination of parental rights, and shortening the time frame to establish permanency plans involving cases that meet the criteria for grounds to terminate of parental rights. The Adoption Assistance and Child Welfare Act of 1980 requires CPS to demonstrate that we make reasonable efforts to provide assistance and services to prevent the removal of a child from his or her home and to allow a child who had been placed in out-of-home care to be reunified with his or her family. Although Chapter 13, Title 19 of the Guam Code annotated does not define what reasonable efforts are, CPS makes reasonable efforts to preserve families prior to placing a child in foster care homes in order to prevent or eliminate the need for the child to be removed from the child's home. CPS continues to work with families that do not require court intervention and link families to services if a CPS referral is deemed inappropriate. CPS would like to know if the legislature aimed to include a statute requiring concurrent permanency planning for timely permanency based on lines 25 and 26. Reasonable efforts to finalize an alternate permanency plan may be made concurrently with reasonable efforts to reunify the child and the family. If this is the case, the term concurrent planning should be defined precisely. If concurrent permanency planning is not intended, the language for reasonable efforts should be reconsidered. Under subsection 13301.2, circumstances negating for reasonable efforts should be titled as grounds for termination of parental rights if the intention is to terminate parental rights based on specific circumstances demonstrating parental unfitness by demonstrating that the child cannot be kept safely at a home due to the risk of harm from the parent or the parent's inability to meet the child's basic needs. Lastly, resources, if needed, can be allocated accordingly to implement this legislation should it become public law. We support the legislature's intention to establish statutes in Chapter 13, Title 19 of the Guam Code annotated to include reasonable efforts to preserve and reunify families, define grounds for terminating parental rights, and shortening the time frame to establish permanency plans involving cases that meet the criteria for grounds to terminate parental rights. Thank you for allowing the Department of Public Health and Social Services, Bureau of Social Services Administration, the opportunity to testify in today's public hearing. As indicated before you in the written testimony, there are some resources that are given to the legislature, and if you would like those resources, I do have them before me if you would like copies of them.
Thank you very much, Ms. Gooden. Anyone else to testify? Mayfei? No? All right. Okay, so I will invite the sponsor to open the questions or comments, if she would like.
Thank you, Madam Chair. I'd like to thank each and every one of you for your very valuable testimony. Mrs. Middlebrook, yours was a very practical and heart-wrenching account of why many of us in this room, including those in the panel, made the efforts to fix the Child Protective Act through Bill 299 as a first step. a lot of those examples were what compelled us, all of us, to find a reasonable ground with 299. So I thank you very much for your testimony with regard to the true stories of the 7 children that you mentioned, the family members. Ms. Broker from Ohala. Broker, I hope I got. Kroger, yes, thank you. Ms. Kroger from Ohala, we will take a lot of your testimony into account. I believe that many of the things you brought up are either already in statute or most of which we had already incorporated into this bill. So we'll double look at what you provided as testimony and make sure that we have considered to the best that we can all of that. But many of the amendments to 299 that were made as a result of the meetings with CPS were, we had to find a middle ground and not go too extreme in our efforts to reach what it would be an ideal situation with permanency placement and termination of parental rights. But I thank you, though, for your testimony. And Ms. Flores, again, thank you always for working with us into bringing some critical issues up that we need to address in order to not only align ourselves with federal standards, but also to align ourselves so that we're better positioned to receive the critical funding to reach out and help families in need and parents in need. And with regard to DPHSS, I was listening intently to your discussion about reasonable efforts. And many of the reasonable efforts that we have written into 299 refer to the activities of the social service agencies that aim to provide the assistance and services needed to preserve and reunify the families. And a lot of what we've written in also was tied in with the federal Title IV program requirements of states to make these reasonable efforts to preserve and reunify families prior to the placement of a child in foster care, to prevent or eliminate the need for removing the child from the child's home, and to make it possible for a child to safely return to the child's home. We're aware that laws in all states require that the child welfare agencies make reasonable efforts to provide these services that will help families remedy the conditions that brought the child and family into the child welfare system to begin with. We also know that Guam's reasonable efforts are found in 19 GCA section 1304.A, which is the service plans that are developed by CPS. I was listening to your discussion about the concurrent, if I can just flip through real quickly and see where that is. You had made a discussion about working concurrently, page 4, in section, yes, in section 13301.1, reasonable efforts to preserve and reunify families. You were talking about reasonable efforts to finalize an alternate permanency plan may be made concurrently with reasonable efforts to reunify the child and family. We will have further discussions on that because we don't believe that we are necessarily working to terminate. There is a concurrent effort, best effort to maintain reunification as we consider the need for the permanency plan. So I don't think, we'll have further discussions on it, but I think that what your concerns have been discussed with, in the meetings we had discussed the way that we would remedy and work through the different scenarios to arrive at the best interest of the child. So I think that may be a further discussion with your team before any suggested amendments are made to that section of the law, which was the new addition. It was a new addition to Chapter 13 of Title 19. But I don't have any questions other than Madam Chair, to just reiterate my gratitude to all of you in the panel and for the collaborative effort. I don't, notwithstanding all the shortcomings of the foster care system in Guam, which we know is a struggle, a constant struggle for our island as a small island community, and with all the social ills that exacerbate the problem, we nonetheless have come to a point where we know that we have to do better, and I don't think that anyone in the group or anyone that has been working with us in developing Bill 299 has a difference of opinion in that regard. And I just want to thank all of you for working with us and with my office and staff in trying to find what would be a reasonable bill to better the Child Protective Act and to also align us with federal programs, bring us into the fold of the standards of federal programs and other states, but also to allow for the ability to tap into additional resources for the island of Guam. Thank you, Madam Chair.
Thank you. If I could ask Department of Public Health, thank you all for your testimony. It's very helpful, and I support this bill. I just have, I guess, a question on, you brought up the word concurrent planning should be defined precisely if that's what is intended. What do you recommend?
So in one of the references in regards to our testimony, there is something that is provided by the Child Welfare Information Gateway regarding concurrent planning for timely permanency for children. And there are actual state statutes that are provided, and if the legislature would like to look at that information, it actually provides a definition as to what concurrent planning is defined.
All right, and are they the same in the different states, or are you recommending that we adopt that or not?
I guess CPS's stance was because of the word that was being used, we weren't sure whether or not your intention was to implement concurrent planning, because that would be a plan for reunification and then a plan for what will happen if permanency does occur.
Okay, I think that is the intent based on how it's read. Okay, so you have some language that you can share with us
Yes.
according to this resource, your first resource provided here.
Yes.
And what about the, it says, right now it's called reasonable efforts to reunify a parent or guardian with a child shall not be required or shall cease if one of the more of the following circumstances exist. And you're suggesting that we change that to be titled as grounds for termination of parental rights, or additional grounds for termination of parental rights. So is it your understanding, the way this is written, that this is a determination made by CPS, or that you need court approval of this determination?
When we read the bill, our interpretation of how the language was worded was that you're identifying what is reasonable efforts and what is not, and the point is we interpret it as the legislature is trying to define what circumstances can CPS then propose to the court to push for a permanency plan on these grounds.
Okay, I agree. All right. Is there in addition to those two sections, is there any other part of the bill that you think needs to be changed?
I think that was the main ones
Okay.
that we had identified.
All right. I appreciate that. And I appreciate the resources provided. There's one section I think I'd like to also include, and that is language to ensure that state, Guam, provides services already offered by the state to improve the chances of family reunification before making the decision to terminate parental rights. So that's not currently in here, but it is provided in section 103A3E3 from the U.S. Public Law 105-89, and it says, it's an exception to the filing of a petition for termination. Quote, the state has not provided to the family of the child, consistent with the time period in state case plan, such services as the state deems necessary for the safe return of the child to the child's home, if reasonable efforts are required to be made with respect to the child, unquote. So we are requiring reasonable efforts. Are you familiar with the time period to provide services to these families? Or do you put a time limit on them to avail prior to this bill?
So if it's a court intervention case, the parent is given there's the preliminary hearing, and then there's the answering. A lot of times CPS have come to the point where it's months of still in an answering state for parents, and a parent has to answer before regarding the PINS petition so that we can go ahead and develop that service plan agreement.
Okay. All right. I don't have any additional questions, but I am grateful again for all of your testimony. Senator Torres, any other additional questions or statements?
Yeah, I just want to follow up on the last comment that was made. The exceptions are contemplated in the bill, and that was the idea that we understand that the best scenario for a child may be to be with their biological parents if they are in a safe and nurturing environment. And we have beginning on page 11, section 6, there are situations where there are exceptions to termination, and on page 12, on number 3 is where we say that, considering page 12 around line 10 is where we consider that if the family of the child has not been provided consistent with a time period in the service plan under current Guam law, which is 19 GCA section 13304, services or treatment that Child Protective Services deem necessary for the safe return of the child to the child's home when reasonable efforts to reunify the child are required. So if we understand that if the parents are in a program already that, or if they have not been provided any services, that they have to be allowed that, or they should be allowed that by CPS. So I don't believe that we have, when we added this new section 4303D to Chapter 4 of Title 19, which is the termination of the parental-child relationships, we are contemplating that while we want to terminate parental rights under aggravated circumstances, one of our intentions as well is in all other situations that the families be afforded the services and the assistance that they need to reunify, and that would be a placeholder and something that would hold them from advancing into termination. So I believe under section 6 of the bill that begins on page 11, we have contemplated where the circumstances where we would yield to CPS to determine if, in fact, they've exhausted all remedies and options to help these families. So I believe, Madam Chair, that before we amend anything, we should maybe go through and just ensure that language is contained in here, which I believe it is, that addresses the concerns. Because I believe there is always that concurrent, while you're looking at one plan, you're also trying to remedy on the back end, and you've exhausted all all efforts to service and provide services to the families and the children prior to the termination. So I hope I'm clear, but we can also get back to you on that, but I believe it's contained in page 11 and 12 already. Thank you.
Does that conclude your closing on the bill? Is that it?
Yeah, I
You may
don't,
close.
I don't have anything. I just want to say, Sizus Maasi, and we look forward to addressing all the concerns and questions that we have, and hopefully if there are any gaps that we didn't put in, that we missed, that we are able to amend. But I think that given the amount of time that we've spent on this, I believe that many of the concerns by CPS and the practitioners have been thought through, and also working with the Bureau of Women's Affairs. I believe that we've addressed a lot of the concerns that led us to Bill 299.
Thank you. Does CPS have any, or DPHSS have any comment on the fiscal note that was provided? Have you had any discussions with your department as to how you will make do if this bill is passed?
Well, the Department of Public Health would require more funding if this bill is passed in order for us to work with our service providers and to provide all the efforts we can to ensure that we write the permanency plan and so forth. But if anything, it should be more funding for our office for public health.
Have you discussed that with the director?
No, I have not.
All right. Okay. There being no additional individuals to present further testimony, the committee will consider Bill number 299-36 COR duly heard. Committee will remain open for the submission of additional written testimony for the next 10 working days following the hearing, which will be November 1st, 2022. Testimony can be sent via email to Senator Terlaje Guam at gmail.com or hand delivered to my office here at the Guam Congress Building. So this public hearing is now adjourned and the time is 12:40 p.m. Situs Masi.